Hello, everybody. Hello. This is a very special bonus live for my subscribers. And everybody, of course, is free to join, but comments are for my subscribers here. I just wanted to pop on and say hello. And thank you to everyone who does subscribe. I'm so thankful for that. I would like to start doing a few little bonuses for everyone that is subscribing. There is this really fun event going on right now to add anybody that is wanting to subscribe. So I thought I would just kind of kick off and do a couple little bonus events for anyone who is interested. So again, thank you all for joining. Again, this is just a little extra bonus added in. I will be at my usual time that I'm normally at on my regular scheduled time as well, but this is just a little bit of a bonus for all of those amazing people that are so supportive and subscribing. I'm so thankful for that. The support is just amazing. So I wanted to do something just a little special for those who are coming and hanging out and supporting. So for those subscribers out there, thank you so much. This is a special event for you. Of course, everyone here is welcome. I wanted to take a few minutes and talk about a plea agreement that was done today. Many of you may have heard of it. This is the U.S. versus Joran Andreas Petrus. So this was a plea agreement that was made out of a very controversial case that had occurred many, many years ago. So he has agreed to plead guilty. I do have his plea agreement here, so I thought I would take everybody through just the first couple of paragraphs to kind of explain what it was about. Again, I've got my special subscribers, a special chat going for that. But also I wanted to share this information with everyone. So welcome, everyone. I appreciate it. Again, I'm just wanting to do a couple of special things for my subscribers. So very thankful for your time and support. So let me just walk you through the beginning here of this plea agreement that was signed. Again, this was a very controversial case. You're amazing. I'm learning so much. Oh, thank you so much. Oh, I appreciate that. I appreciate that so much. Thank you. Oh, you're welcome, Bumblebee. Good to see you. Yes, I wanted to do just something a little special for everyone who's been so supportive out there. I'm so thankful. Hello, Sequin. Hello. So I will probably be doing some sub-only bonus ones here for my subscribers. I'll probably start trying to do that. I'll be setting up a more regular schedule, but tonight I wanted to kind of kick off with this very interesting plea agreement. So we should be good to go and not really needing our moderators too much because this is a really special session for everyone. So thank you so much, everybody, for your support. So let me go ahead and start taking you through this plea agreement. This was a very controversial case that happened. So again, this was done just today. We have, yes, oh no, I'm fine. I'm just doing a little special live, bonus live tonight for my subscribers. Everyone, of course, is welcome to join, but just an extra special one for just to say thanks to all my supporters out there. So we have a binding plea agreement. The United States and the defendant, Joran Andreas Petrus van der Sloot, also known as Joran van der Sloot, hereby acknowledge the following plea agreement in this case. Here's the plea. Okay, love you. Oh, thank you. Thank you. Yes, just doing a special bonus tonight. The defendant agrees to 1, plead guilty to the indictment filed in the above referenced matter. 2, consent to the forfeiture as described in Section 8 below. 3, pay restitution of $25,100. And 4, waive certain rights to direct appeal in collateral attack as outlined in Section 5 of this agreement. In exchange, the United States Attorney, acting on behalf of the United States and through the undersigned Assistant United States Attorneys, agrees to recommend the disposition specified below, subject to the conditions in Section 8. So I won't be reading every single line, but I will just take you through the fact pattern here and what he has agreed to plead guilty to. Overall, these are the terms of the agreement, and this is a really great example of what an agreed plea agreement looks like. First, we have a maximum punishment here. The defendant understands the maximum statutory punishment that may be imposed for the crime of extortion. Can we have a post-it? Absolutely. Hold on. You bet. For you, anything. Oh, hold on. Let me make sure I spell his name correctly here. Here we go. U.S. v. Joran Van der Sloot plea agreement. All right, so one moment. You should feel special. Yes, of course. Thank you, all of my wonderful supporters and subscribers. Even if you are not subscribing, I'm, of course, thankful so much for you. But I wanted to do something just a little extra special for everybody. So here we go. Here's our plea agreement sticky note. So let's go through the maximum punishment here. The defendant understands the maximum statutory punishment that may be imposed for the crime of extortion in violation of Title 18, United States Code Section 1951A, as charged in Count 1, is imprisonment for not more than 20 years, a fine not more than $250,000. He got away with a lot, but I'm glad his luck ran out. I agree. Or both A and B, supervised release of not more than 3 years, and a special assessment of $100. The defendant understands the maximum statutory punishment that may be imposed for a crime of wire fraud in violation of Title 18, United States Code 1343, as charged in Count 2, imprisonment not less than 20 years, a fine of not more than $250,000, or both A and B, supervised release of not more than 3 years, and a special assessment of $100. So this is really the part I wanted to share with everyone, was the factual basis for this plea agreement. So, Cozy, is this in frame well enough for everybody? I just want to make sure. It looks good to me, but now that I've got some people I can just ask specifically to, that's very helpful for me. So let me know if I'm in frame, okay? Okay, thank you so much. All right, here's our factual basis for the plea. The United States is prepared to prove, at a minimum, the following facts at this trial of this case. From at least 2005 to May of 2010, defendant Van der Sloot was a citizen of the Netherlands, residing in Aruba. During a May 2005 high school graduation trip to Aruba, Alabama native Natalie Holloway disappeared while in defendant Van der Sloot's company. Natalie Holloway's location and the circumstances surrounding her disappearance have been unknown to her family, friends, and law enforcement since May 30th of 2005. In March of 2010, this is a subscriber comment only special event. Everybody, just a special bonus for my subscribers. Of course, everyone is welcome, but just doing a special chat option for my subscribers tonight to give my moderators a break and as a thank you. In March of 2010, defendant Van der Sloot contacted John Q. Kelly, an attorney for Natalie Holloway's mother, Elizabeth Ann Holloway, via email seeking $250,000 in exchange for the location of Natalie Holloway's remains and information regarding her death. Kelly often served as the intermediary for Ms. Holloway during her efforts to find her daughter. Anxious to obtain information regarding her daughter, Ms. Holloway and Kelly discussed the transaction. During April and May of 2010, defendant Van der Sloot and Kelly exchanged numerous emails regarding defendant Van der Sloot's request for $250,000, how the information regarding Natalie Holloway's remains would be provided, and details of Kelly's travel to Aruba to meet with defendant Van der Sloot to conduct the transaction. At one point, Kelly asked defendant Van der Sloot what would happen if Miss Holloway failed to provide the money, and the defendant, Vandersloot, demanded. Defendant Vandersloot replied that Miss Holloway could wait another 5 years, causing Miss Holloway actual fear that she might never know what became of her daughter. How long ago was the crime? It was a long time ago. It was a long time. Yeah, it was very sad. It was very sad. To complete the transaction, Defendant Vandersloot provided his bank account information to the bank in the Netherlands to Kelly. To confirm the legitimacy of the account, Ms. Holloway sent a wire transfer of $100 to Defendant Vandersloot's account from her bank account at Regions Bank in Birmingham, Alabama. Ms. Holloway subsequently confirmed that the funds had been deposited into Defendant Vandersloot's account at an SNS bank. Kelly and Defendant Vandersloot agreed that Kelly would travel to Aruba in May of 2010 to provide an initial down payment of $25,000 to the defendant in furtherance of his demand. Ms. Holloway and the defendant executed a written agreement confirming that following the initial payment of $25,000, Defendant Vandersloot would reveal to Kelly the location of Natalie Holloway's remains and would share the details of her death. The agreement further provided that after the remains were secured and confirmed to be Natalie Holloway's, Miss Holloway would provide the remaining $225,000 to Defendant Vandersloot via wire transfer to his bank account in SNS Bank. This is such a sad case. On May 10th of 2010, Kelly and Defendant Vandersloot met at the Aruba Marriott Resort and Stellaris Casino. Kelly provided $10,000 cash to defendant. Following that payment, Ms. Holloway initiated a wire transfer of $15,000 to defendant, his bank account at the SNS Bank. Defendant then reported to Kelly details surrounding Natalie Holloway's death and accompanied Kelly to a specific location in Aruba where he reported that Natalie Holloway's remains were located. However, as the defendant knew both the details of Natalie Holloway's death and the location of her remains that the defendant provided to Kelly were false. Despite this fact, defendant retained the $25,100 provided by Ms. Holloway. On approximately May 13th of 2010, the defendant left Aruba. Following Kelly's meeting, I can't imagine how the mother felt. Oh, I know. Oh, it's heartbreaking. Following Kelly's meeting with defendant, with the assistance of special agents from the FBI, worked to confirm that Natalie Holloway's remains were not located at the place identified by defendant. The defendant had reported to Kelly that Natalie Holloway's body was placed under the foundation of a building near the Aruba Racquet Club that was under construction on May 29th of 2005. Authorities reviewed satellite imagery. Oh my goodness, thank you so much. Oh, beautiful. I appreciate that. And information from building inspectors in Aruba for the specific lots of Aruba Racquet Club where the defendant reported Natalie Holloway having been had been buried. Authorities also interviewed the owners of the lots at the Aruba Racquet Club regarding the timing of their lot purchases and construction of homes located on the lots. Based on this information, Ms. Holloway confirmed that there were no buildings under construction on the lots identified by the defendant during his meeting with Kelly. Further, the defendant confirmed in an email to Kelly following the transaction that the information he had provided was worthless. The defendant hereby stipulates that the facts stated above are substantially correct and that the court can use these facts in calculating the defendant's sentence. The defendant further acknowledges that these facts do not constitute all of the evidence of each and every act that the defendant and or any co-conspirators may have committed. So here's the first part, again, of this plea agreement. Here's the stipulated sentence. So let's take a look and see what he has what they stipulated to. That means both parties agreed. Pursuant to Rule 11C1C of the Federal Rules of Criminal Procedure, the United States and the defendant stipulate that the following terms are the appropriate disposition of the case. Now, everyone can agree, but ultimately it is left up to the judge. A, B. Oh, thank you. Thank you so much. A, that the defendant receive a sentence of 240 months with credit for time spent in custody in the United States since June 8th of 2023, said sentence to run concurrently with the defendant's currently imposed sentence in Peru. Concurrently means at the same time as opposed to consecutively, which would mean one right after the other. That following the said term of imprisonment, the defendant be placed on supervised release for a period of 3 years, subject to the court's standard conditions of supervised release and any special conditions imposed by the court at sentencing. C, that the defendant be required to pay restitution of $25,100 to Elizabeth Ann Holloway. D, that the defendant be required to comply with the forfeiture provisions set forth in Section 8 of this agreement. And E, that the defendant pay a special assessment of $200, set amount due and owing as of the date sentence is pronounced. The United States and the defendant further understand and agree that this agreement does not affect the court's discretion to set any lawful conditions on supervised release, not otherwise stipulated to in this agreement. In the event the court rejects this plea agreement, either party, oh, Kristen, thank you so much for that, and thanks for the wonderful present. I appreciate that. Is it Ice Horse? Oh my gosh. Either party may elect to declare the agreement null and void. Should the defendant so elect, the defendant will be afforded the opportunity to withdraw his guilty plea pursuant to the provisions of Federal Rules of Criminal Procedure 11D. All right, so the court has said, all right, we are going to agree, but there could be some different pieces involved. So this is really what they were wanting, was this element of cooperation, what the defendant would be able to provide in order to get this guilty plea. Cooperation. The defendant's agreement to cooperate. The defendant agrees to the following provisions pertaining to cooperation and assistance. Extortion and wire fraud cooperation. The defendant will honestly and completely assist law enforcement agencies concerning the investigation into the extortion and wire fraud scheme with victim Elizabeth Ann Holloway that occurred between March and June of 2010. The defendant will be fully debriefed by personnel of the United States Attorney's Office and representatives of the FBI, as may be determined by the United States Attorney. The defendant will provide all information and evidence within his knowledge or control concerning the investigation. All such information will be full, complete, accurate, and truthful. The determination of the United States Attorney as to the completeness, accuracy, and truthfulness of the information and evidence provided concerning the investigation shall be final and conclusive. The defendant will provide all documents, physical evidence, and electronic evidence within his possession concerning the investigation. That's specific to the wire fraud. So let's talk about the Natalie Holloway cooperation. The defendant will honestly and completely assist law enforcement agencies concerning the circumstances of Natalie Holloway's disappearance on or about May 29th of 2005. The defendant will be fully debriefed by personnel of the United States Attorney's Office, representatives of the FBI, and others, as may be determined by the United States Attorney. So he is being required to assist with that investigation. The defendant will provide all information and evidence within his knowledge or control concerning Natalie Holloway's disappearance. All such information will be full, complete, accurate, and truthful. The defendant understands and agrees that Elizabeth Ann Holloway and Dave Holloway, Natalie Holloway's parents, will be allowed to hear the defendant's debrief with representatives of the United States Attorney's Office and the FBI. If the United States determines that it's necessary, the defendant will submit to a polygraph examination administered by an agent of the United States following his debrief. The defendant further understands and agrees that following this debrief, the United States, in consultation with Elizabeth Ann Holloway, will make a determination regarding the completeness, accuracy, and truthfulness of the information and evidence provided by the defendant regarding Natalie Holloway. Said determination shall be final and conclusive. Could you move the paper to the left a tad? Absolutely. How's this? I'll wait for your response, Cozy, before I go forward. Is this okay? Is that better? Dun, dun, dun. Perfect. Okay, thank you. Yes. Okay, you got it. You got it. Love that. All right. The defendant understands and agrees that should the results of the polygraph examination be unsatisfactory to the United States, or should the U.S., in consultation with Elizabeth Ann Holloway, determine that the information provided by the defendant was not complete, accurate, and or truthful, the plea agreement will be deemed null and void pursuant to Section 8 herein. United States agreement in exchange for cooperation. So we're saying here, what's the United States agreeing to in exchange? United States sentencing guidelines. The U.S. attorney will not use information or evidence provided by the defendant during the defendant's assistance in the investigation against him. The United States will recommend the terms of the binding plea agreement to the court. Specifically, defendant receive a sentence of 240 months in exchange for pleading guilty to the indictment pending against him. Said sentence to run concurrently with the previously imposed sentence the defendant is currently serving in Peru. The United States will acknowledge the defendant's truthfulness during his debrief with representatives from the FBI and the United States Attorney's Office to the court at the time of sentencing, noting that the defendant's truthfulness provided closure to the Holloway family. Waivers. Statute of limitation waiver. In consideration of the recommended disposition, the defendant hereby understands, acknowledges, and agrees that if this plea agreement is set aside for any reason, he will not assert any defenses based on applicable statute of limitations or the Speedy Trial Act. So that's very important. That includes the passage of time from and including the date this plea agreement until and including the date of entry of any order setting this plea agreement aside. Hello, Suze. Welcome. Yes, just doing a little special reading for my subscribers as a huge thank you for all of your support. Right to appeal and post-conviction relief. In consideration of the recommended disposition of this case, the defendant hereby waives and gives up his right to appeal his conviction and or sentence in this case, as well as any fines, restitution, and forfeiture orders the court might impose. Further, he waives and gives up the right to challenge his conviction and or sentence it, any fines, restitution, forfeiture order imposed, or the manner in which his conviction and or sentence, or any fines, restitution, forfeiture orders were determined in any post-conviction proceeding, including but not limited to a motion brought under 28 U.S.C. 2255, and any argument that 1, the statute to which he's pleading guilty is unconstitutional, or 2, the admitted conduct does not fall within the scope of the statute. So again, this particular section, he's just waiving all of his appellate rights in this particular situation, which is a huge piece. I think a lot of people forget about that we can actually put that into our plea agreements, that the defendant is agreeing to not appeal certain things. And if things fall through, they're agreeing that they're not going to argue certain things. This is actually really huge, a huge part of our plea agreements. A lot of people don't know that. So he's signing it here, saying he agrees again to these restrictions on his rights for appealing, particularly if the plea agreement falls apart. U.S. sentencing guidelines. Counsel has explained to the defendant that in light of the Supreme Court decision, U.S. v. Booker, the guidelines are advisory in nature, and so they're basically just saying, hey, we can advise what we can advise, but ultimately it is up to the court. The court may use facts it finds by a preponderance of the evidence to reach an advisory guideline range. Defendant explicitly waives any right to have those facts found by a jury beyond a reasonable doubt. So he's saying, I will leave it up to the judge. I will not request a jury. Agreement binding on the court. So here it's just saying that this agreement binds the court. Once the court accepts the plea agreement, the defendant can withdraw the plea agreement if the court rejects the plea agreement. So if the court agrees, then we go forward. But if the court doesn't agree, it's okay. He can kind of step back and they can renegotiate. And then voiding the agreement, he understands that the defendant violates any federal, state, or local law after entering into this plea agreement, moves the court to accept a plea agreement in accordance with or pursuant to the provisions of this Alford agreement, You may have heard this phrase before, an Alford plea agreement. An Alford agreement means you're agreeing to plead guilty, but you're saying you didn't actually do it. It's counterintuitive, but it's just a type of plea agreement that we use sometimes in order to negotiate the situation. Tenders a plea agreement of nolo contendere to the charges. Nolo contendere means no contest, so this actually means it's the nolo contendere piece. D, violates any other term of this plea agreement or does or says anything that is inconsistent with the acceptance of responsibility. The plea agreement will be null and void at the election of the United States. The United States will not be bound by any of the terms or conditions or recommendations express or implied which are contained herein. Further, such election will not entitle the defendant to withdraw a previously entered plea. So I'll pause here just for one moment. Okay, so again, he's just agreeing to multiple terms. At that point, would this go to trial? It's possible. It's possible. If the judge doesn't agree to the plea, he can renegotiate, which is huge because a part of this plea is that he wouldn't go forward and pursue a jury trial, but that's only if the judge agrees. Other jurisdictions here, it does not bind against any other state or local authority. Collection of financial obligations set out here, so I'm not going to go through that. That's really just billing information for the financial obligation. So he needs to pay full restitution back for the harm that was done. An agreement regarding relevant conduct and restitution, again. So this, again, just is going into details of what his responsibilities are. He's not allowed to break any laws. He does need to give back the restitution. Tax forfeiture and other civil administrative proceedings. So he acknowledges this agreement does not apply to or in any way limit any pending or prospective proceedings relating to the defendant's tax liabilities. So that's just another piece that we will put into our plea agreements when we put them together. Now, here's the big piece that they were referring to before. This is Part 8, the forfeiture. Defendant agrees to consent to the immediate entry of a final order of forfeiture against the defendant in the amount of $25,100, which represents proceeds the defendant personally obtained, controlled, and benefited from as a result of offenses alleged in the indictment, and to which the defendant is indicating the defendant desires to plead guilty by way of this written binding plea agreement. For purposes of entering said order of forfeiture, defendant acknowledges that a nexus exists between said amount and the criminal offenses to which the defendant is pleading guilty. I'm curious how they will know if he's forthcoming. That's a great question. I think it's interesting that they are requesting a lie detector, a polygraph. So, as I'm sure everyone knows, that kind of information is not admissible in court. So there's another reason why they're seeking that information. So the forfeiture is from the $25,100 that he gained through illegal means. So he needs to pay that back. And that's what the forfeiture section is about here. So, non-abatement of criminal forfeiture. So the defendant agrees the forfeiture provisions of this plea agreement are intended to and will survive the defendant, notwithstanding the abatement of any underlying criminal conviction after the execution of the agreement. The forfeitability of any particular property pursuant to this agreement shall be determined as if the defendant had survived. So what happens if he passes away? His estate still has to pay it. The lie detector seems odd. Suze, I think that they requested it because of her parents. I think her parents are so heartbroken, which is what led to this whole situation, that they just want to know what happened. And so I think the lie detector, the polygraph, is so that the parents can get some closure. Right. What her mom asked for, exactly. But it is different. That is not something that would normally be included in this kind of a situation. Yeah, I would want the truth as well. All right, so if he passes away, his estate still has to continue to pay. forfeiture and restitution language in the final judgment. So they understand and agree that the provisions of Title 18 apply to the forfeiture judgment against the defendant, and that all non-federal victims must be paid before the United States receives any restitution. The United States and the defendant further understand and agree that the victim's recovery is limited to the amount of their loss, and the defendant's liability for restitution ceases if and when the victim receives full restitution. Accordingly, the United States and defendant understand and agree that any monies collected by the United States through the forfeiture shall be remitted to Elizabeth Ann Holloway in satisfaction of defendant's restitution obligation. Yeah, they've been waiting 18 years. I know. It's a tough case. Immigration status. The defendant recognizes that pleading guilty may have consequences with respect to the defendant's immigration status if the defendant is not a citizen of the United States. Under federal law, a broad range of crimes and removable offenses, including the offense to which the defendant is pleading guilty, the defendant's guilty plea and conviction make it practically inevitable and virtually certain and a virtual certainty that the defendant will be removed or deported from the United States if the defendant is not a citizen of the United States. Removal and other immigration consequences are the subject of separate proceedings. However, the defendant understands that no one, including his attorney or the district court, can predict to a certainty the effect of his conviction on his immigration status. Understanding all of this, the defendant nevertheless affirms that the defendant wants to plead guilty regardless of any immigration consequences that plea may entail, even if the consequence is automatic removal from the United States. Defendant's acknowledgement. So now we need to make sure that he understands what's going on. So this is another key piece to this plea agreement as well. Defendant's acknowledgement. I have read and understand the provisions of this binding plea agreement consisting of 23 pages. I've discussed the case and my constitutional and other rights with my lawyer. I'm satisfied with my lawyer's representation in this case. I understand that by pleading guilty, I will be waiving and giving up my right to continue to plead not guilty to a trial by jury, to the assistance of counsel at that trial, to confront, cross-examine, or compel the attendance of witnesses, to present evidence on my behalf, to maintain my privilege against self-incrimination, to the presumption of innocence. I agree to enter my plea as indicated above on the terms and conditions set forth herein. No promises or representations other than those in the agreement have been made to me by the prosecutor or by anyone else, nor have any threats been made or force used to induce me to plead guilty. This, of course, is what we have to put in all plea agreements. No matter what the situation is, we have to make sure that the defendant understands that. I further state I have not had any drugs, medication, or alcohol within the last 48 hours except for prescription medication. Well, hello. Welcome, everybody. Welcome. Doing a little special bonus live for everyone to join, but specifically for my subscribers to be able to comment. I have personally and voluntarily placed my initials on every page of this binding agreement and have signed the signature line below to indicate that I have read, understand, and approve all of the provisions in this binding plea agreement, both individually and as a total binding agreement. His dad may... Oh, really? Interesting. Counsel's acknowledgement. So here he has signed it here, and as you can see down at the bottom corner of each page, he's initialed it, which is typically what we do as well as counsel. We will go through and initial pages like this as well. So, counsel's acknowledgement. I've discussed this case with my client in detail, have advised my client of all of my client's rights and all possible defenses. My client has conveyed to me that my client understands the binding plea agreement, consents to all its terms. I believe the plea and dispositions set forth herein are appropriate under the facts of this case and are in accord with my best judgment. I concur in the entry of the binding plea agreement on the terms and conditions set forth herein, signed by his counsel. So he has two attorneys here. His dad did pass away. Okay. Oh, I didn't know that. Okay, so everybody agreed, and then the very last piece is we have the United States of America acknowledging it. I've reviewed this matter as the binding plea agreement and concur that the plea and dispositions set forth herein are appropriate and are in the interests of justice. Signed here by United States attorneys. So that is the plea agreement. That's the binding plea agreement that was set out in this case. This was a very difficult case, very heartbreaking. So it was pretty big news when it came out that he had agreed to plead guilty. It will be interesting to see what actually happens after they question him and go into the details to see if he actually has any information. So I'm not sure if he does or not, but we will see. Where is he in the U.S.? I think he's in Peru. Hello, Paralegal Life. Welcome. I think he's in Peru at the moment. Yeah, Peru. He's got some time he's got to serve there. He's a mess. He's got a lot going on. He's got a lot going on in this situation. So, but this was pretty major. I really hope that the parents get some kind of closure on this, get some kind of information. So he has agreed to cooperate. He has, the U.S. has agreed to not file charges against him if he gives information. So he's already in trouble for other situations in Peru. So it would really be in his best interest to kind of get it all taken care of. That's a long name. It certainly is. It certainly is a long name. Oh my goodness, it's a long name. So there we have it, everybody. Short, but very interesting. I think a very interesting case. So I would like to do some of these special, what's worse, the Peruvian jail or an American jail? It depends on where you're at, I think, in the U.S., although federal prison isn't too bad, but it's very Dickinson-y. Yeah, it is. I will be coming back and doing some very fun extra bonus subscribers only lives. I really have been trying to figure out a way to say thank you for all of the support and the kindness. And so I thought the best way I could do it would be to just have a few special sessions. So I'm not sure if her father was an attorney in Aruba. Really? His father was. Okay, that's interesting. So I did want to ask before I let everyone go, will you announce it? Well, that's kind of what I wanted to talk about just a little bit. Kristen, I can do a late evening after my regular lives. I need about an hour or so to be able to come back to get my voice back, or I can do it at a different time during the day. So I wanted to kind of take a poll and see what works better for you. It would just be, we'd be just doing a short one. It wouldn't be too long, but it would be something not related to my usual lives. So just our extra bonus ones. Appreciate how I've learned from you. Oh, thank you. I'm so glad. Sentences should be consecutive with Peru. Whatever works best for your voice. Okay. Well, so the two times that I'm thinking of would be kind of this later time, depending on the West Coast. So it would best to be, ask the East Coast in the evening. Okay. Well, I usually, I do my 7 to 9s. And so it takes me I need about an hour and a half in order for me to rest my voice. But then I can come back and do probably about an hour. So what I'm thinking is that I might do, is just kind of plan at 11 o'clock p.m. Central Time. Will probably work the best for me and my voice. I won't be able to do for too long, but definitely for a little bit. And we will just do some bonus cases, some interesting bonus things that are going on. So we'll kind of start at 11 to do that. So yes, and if that 11 o'clock p.m. doesn't work, what I'm thinking is that I'll do one evening like this, but then I'll also do 12 o'clock p.m., so at noon during the week as well. Just past 9 here. Will these be recorded and posted on YouTube? Yes, they will. I will be recording these. So these will just be special for the subscribers to be able to comment. So my moderators can kind of have this time off. Everyone, of course, is welcome to come and listen. But when it comes to making comments, this will just kind of be a bit of a special event just for my subscribers to be able to comment. Of course, again, everyone can join, but if you want to comment, those will be just for my subscribers. So, We will start then with the 11 o'clock. So today's our first one. So I will set this out, by the way, in my messages. All the subscribers get a special message note from me. You should be able to look that up. So I will set the schedule out in that note, okay? So look for that note in your subscription. I will set out Wednesdays at 11 p.m., and then I'll double check the calendar and try to pick out maybe one day when I do a 12 o'clock, so like a noontime Central Time. But we'll just be doing a bonus case that's just something interesting going on in the world, okay? Yeah, no trolls. No trolls, yep. But again, I will set out a message for anyone who's subscribing. You'll be able to see my messages when I send them out. So we will look forward to that. So tonight will be our first night, and I will see what I can do to schedule out our next one. But we'll definitely be back Wednesday at 11 next week. But I may do another one before that. I will definitely put an announcement in your subscriber notes. So take a look back there. But again, everyone, of course, is welcome to listen in and learn and find out something new. But this is a special commenting time for anyone who is subscribing. So thank you, everybody. I will go ahead and sign off at this point. Oh, yes, my voice is okay. Yes. Rocky Mountain of Evidence. Oh, my goodness. That's so fun. Yes. Thank you, everybody. Yes, of course. So I'll be back to do a special one next week for sure, but I'll be back at my usual scheduled time for everyone. So take care. Have a wonderful night. And again, I'm so thankful for all of the support. I really appreciate it. It really gives me a boost to come on and know that everyone's got my back. So thankful for your time, everybody. Have a great night. I'll be back at my usual time tomorrow. Thank you. Thanks, Sunny, for that. I appreciate it so much. All right. Take care, everybody. Have a great night. You're easy to love. Oh, Sue, you're so sweet. Oh, my goodness. All right. Have a great night, everybody.